Hello, I'm Natasha Gutierrez. Welcome to Rappler Talk. With me today is attorney Francis Lim, who is the former president of the Philippine Stock Exchange and the counsel for Rappler. Attorney, welcome to Rappler.
Thank you for having me here, Natasha.
I know, sir, you've been speaking to a lot of different people about obviously the case of Rappler and what had happened 2 weeks ago now, or last week.
Last week, yeah.
With the Securities Exchange Commission decision. For you personally, let's start with what shocked you with this case and why did you decide to take it?
Well, from a legal perspective, I was surprised why the SEC had decided the way it did. Because the question provision is a standard covenant in many agreements and even in articles of incorporation of nationalized companies. And these articles of incorporations were approved, many of these were approved by the SEC a long time ago. For example, the provision on the PDR of a BDR, which says that Rappler Holdings Inc., which is the issuer of the PDR, undertakes to cause Rappler Inc. Not to amend its articles of incorporation of bylaws without the consent of 2/3 of the PDR holders is a standard covenant. Not only in joint venture agreements, in shareholders agreement, even in loan agreements. And as I said a while ago, there are many instances involving joint venture companies between foreigners and Filipinos that contain similar provisions. So I think, I hope it doesn't happen. What if the Filipino counterparts of these foreign investors ask the SEC to review these articles of incorporation of these nationalized companies? How will the SEC deal with it? For me, with due respect to my friends in the SEC, sort of an overkill that may put our regulator, the SEC, in a bind.
You keep saying it's standard, and a lot of companies have this. How common is it exactly to have a PDR, or Philippine Depository Receipt?
Well, PDR is not very common in the Philippines, but there have been instances. For example, ABS-CBN, GMA Holdings, and even PLDT have PDRs. In fact, in the case of PLDT and other publicly listed companies here in the Philippines, they listed their PDRs or they issued PDRs abroad. It's a financial instrument that is very popular offshore. It's not only being done in the Philippines, but it's done elsewhere in the world in other markets.
And let's move back a bit. For all of, I guess, the debate surrounding this, what exactly is a PDR? How is it different from a loan agreement or a share of stock? Can you describe that to us, I guess, in the most simple, way?
PDR is essentially a depository receipt. It's a financial instrument that gives the holder, for example, in this particular case, Omidyar and NBN, some economic benefit or economic interest without being a shareholder or of a shareholder of the company whose shares form the underlying assets for a PDR. In a PDR system or in a depository receipt system, there are basically two companies involved. The one is called the depository company or the issuer company, in this case, Rappler Holdings Inc. And the other one is a company whose shares form the underlying asset of the instrument of the PDR or the depository receipt. It's like a derivative. Okay. Now, it's different from a share of stock because a share of stock gives ownership and control over the company by the PDR holder. And a share of stock gives the shareholder, makes the shareholder an owner of the company. It gives the shareholder the right to vote in the election of the directors of the company. And a PDR holder, like Omidyar in this case, does not do that, does not have that right. Now, it's different from a loan agreement because in a loan agreement, the lender, in this case, for example, a bank, receives economic interest, but it's a fixed rate, let's say 6% per annum. PDR, no, it depends on the performance of the share of stock of the company whose shares form the underlying assets. So if the company, for example, Rappler Inc. does very well, the PDR holder gets more. It's not fixed. It's not fixed at 6% or at 5%.
Okay.
It can be, what do you call this, more than that.
So without any ownership or control, that's very clear that PDRs don't give that. Why then would a foreign company invest or use a PDR?
It's normally resorted to by foreign investors, like a foreign company like Omidyar, because of nationality restrictions. For example, in the case of media, under our constitution, a media company can be owned and managed only by Filipinos. So there's no chance for a foreigner to be able to own or manage a media company. So what the media company does, as in the case of CBS, ABS-CBN, and GMA, they form another company. It's called, in the case of ABS-CBN, it's called ABS Holdings. In the case of GMA, it's called GMA Holdings. And these two companies, these holding companies, own shares of stock in ABS-CBN and GMA, the media company. And in turn, it issues PDRs to the investing public. In fact, in the case of these two companies, ABS-CBN Holdings and GMA Holdings, their PDRs are listed in the Philippine Stock Exchange. So it's a recognition by our government that these are financial instruments that can be issued to the public. Now, you may ask me, what's the difference between the PDR of these two companies from the PDR of ABS? So in the case of Rappler Holdings, there are only two investors, okay, Omidyar and NBN.
North-based media.
North-based media. And under our securities regulation code, if the offering or if the issuance is to not more than 19%, you don't need to register it with the SEC. It's called a private placement, and that's the reason why the PDR of Rappler Holdings was not subject to any public offering requirement. Because if it's a public offering, issuing it to more than 19, the issuer has to go through a very rigorous process, prospectus and so on and so forth. But since there are only two investors that are required, you don't need to. It's exempt from registration.
Okay, so let's hone in on the specific PDR of Omidyar that has been the root of this whole case. Did the clause in question allow Omidyar veto power?
It's not the veto power that we normally understand. Because if you look at the way the Omidyar PDR reads, it merely says, Rappler Holdings Inc. shall cause Rappler Inc. not to amend its articles of incorporation or its bylaws in such a manner that would be prejudicial to the interests of the PDR without getting the two-thirds consent. So it's an obligation of Rappler Holdings Inc. Now, what if, despite the effort of Rappler Holdings to get the consent, Rappler Inc. does not comply with the request of Rappler Holdings Inc. pursuant to its contract? Remember that the contracting parties here are Rappler Holdings Inc. and Omidyar. The contracting party is not really Rappler Inc. So in that case, Rappler Inc. may proceed to amend its articles of incorporation of bylaws even without going through that requirement, getting the consent of Omidyar. Now, what happens? Omidyar will just treat it as an event of breach or default.
Okay.
In such a case, Omidyar said, you, Rappler Holdings, you violated our agreement. So I give up my investment, pay me back. That's all that will happen. I don't think, and I think it's very clear that that question clause or provision will make Omidyar the owner.
Or translate to control.
The owner or the management of Rappler Inc. Matter of fact is that there's nobody here. Nobody's been here from Omidyar. Have you seen any Omidyar personnel here or officer intervening in the management of Rappler Inc.? None.
None.
Okay.
Have there been similar situations like this before? Could you walk us through the process of the SEC when a similar case like this comes about, if there is a question in terms of PDRs? And what is the usual process in terms of length of time? And what have you seen before has been this normal procedure? And is this particular treatment of the Rappler case different from that?
I don't recall any other case where our Securities and Exchange Commission has invalidated a PDR. I think this is a case of first impression.
Okay.
This is the first time to my knowledge. I don't know if I may not know everything, but I'm not aware. I've been president of the stock exchange for 6 years. I've been in the practice of law since 1980, but I'm not aware of any instance where the SEC invalidated a PDR, much less invalidated the certificate of incorporation or registration of the company whose shares from the underlying asset of the PDR. I'm not aware.
Okay, so this is the first time. It's a historic, I guess, decision for the SEC. Why should businesses be concerned about this decision?
Well, as I was saying a while ago, what if in, let's say, Filipino shareholders of nationalized companies, no, whose articles of incorporation contain a similar provision? What if they now go to the SEC and ask the SEC to review the articles of incorporation of that company because it contains a similar clause? What will the SEC do? Will the SEC now revoke the certificate of registration of these companies as it did to Rappler Holdings and Rappler Inc.? Will the SEC now revoke or cancel or declare null and void the PDRs of this, the articles, the shareholders agreement of these companies? And if the SEC does that for the sake of consistency, okay, I think that will have a disastrous effect on the rights of investors, especially minority shareholders who insist on this kind of provision to protect the minority stake. Now, if the SEC does that, what will happen to President Duterte's efforts to lure or attract more foreign investors into the country? I think, in fairness to him, the president has been going out of his way to attract more foreign direct investments. But the fact of the matter is that until the Constitution is amended or revised to take out those nationality restrictions, PDRs or this kind of clauses will continue to exist. Because if I were a minority shareholder, I want this protective mechanism to protect my investments from my rights from being abused by my local counterparts. So, in fact, there is a Supreme Court decision which says that giving veto rights or veto power to minority shareholder, to a minority shareholder or shareholders is not equivalent to ceding control to that shareholder.
So there is
a Supreme Court decision, and I think it's based on the deliberations of the Senate. So there is a very clear distinction between a negative covenant or a veto power with control.
Okay. You very well walked us through the technicalities and the business, the decision in terms of the business. How about press freedom? Do you believe that this is a press freedom issue?
I think to the extent that the SEC revokes Rappler's certificate of incorporation, people may argue to be a press freedom issue. No? But I don't want to ascribe any bad faith on the SEC. I'll just deal with the legalities of the issue. Of course, constitutional arguments can be made. And in fact, we intend to raise that too, no? That this kind of decision has a chilling effect on press freedom. Okay? Whether or not Rappler is media company, as contemplated in the Constitution, is itself an issue. Okay? For example, some say it's a technology platform that happens to where that can be accessed by the reading audience, by the viewing public, but that itself as an issue is an issue. It's an issue separate and distinct from the nature of the PDR. No? But Well, we're still preparing our appeal with the Court of Appeals, and we may include that kind of argument, but I think that's more for the press freedom people.
Okay, so you answered that in a way that gives good faith to the SEC.
Yes, yeah.
But let's also not forget the cybercrime case that the NBI is investigating.
Yeah.
What does that say about press freedom given this existing case with the SEC? And could you comment about that as well? As you're
I think
familiar?
the reason why people are suspicious is the sequence of events, and I don't blame them for that. For example, it's public knowledge that the president mentioned Rappler together with other media companies in his, I think, SONA. And shortly thereafter, there was this complaint or referral by the Solicitor General to the SEC. Then the SEC did its own investigation. Okay. Then I think thereabouts, then there was this decision, and almost at the same time, the Secretary of Justice has ordered an investigation into the Anti-Dummy Act component of this case. Then there is that other cybercrime case investigated by the NBI. So I don't blame people, no. But as I said, I want to give the benefit of the doubt. No, I cannot buy. This is my personal opinion, but I'm just focusing on this purely commercial and business matter of the issue because that's where my expertise is. I know I've taken up constitutional law way back in law school. I often raise constitutional issues before the courts of law when it is necessary to promote and defend the client's right. And I think I will do the same here. No? I will raise a constitutional constitutional issues in our petition for review with the Court of Appeals. For example, I said a while ago that this revocation order is an overkill that might put the SEC into a bind. In my view, if there's any violation at all, okay, the penalty of nullifying the PDR, much more with revoking revoking the very corporate existence of a company, is too severe, too onerous a penalty. And from a legal perspective, the constitutional issue that may be raised there is violation of substantive process, the substantive due process. In law, I learned that there are two kinds of due process. The procedural, giving a party the chance to be heard and to be tried before he is condemned. And the substantive, whether a particular law, a particular order is too cruel, and whether the penalty is too severe. It raises a constitutional issue on substantive due process, and I intend to raise that.
Was it too much to ask for the SEC to give us a curative period, the same way that I understand the PLDT case received that sort of treatment?
You know, there is a provision in the Corporation Code which basically says, I think it deals with amendments of articles of incorporation and bylaws. And the provision basically says that if the SEC finds anything objectionable in the articles of incorporation or in the bylaws, the SEC shall grant the concerned party time to cure it, to remedy it. Okay? So there is an express provision in the Corporation Code. So why did the SEC not do that? That's one. Now, in the famous PLDT case, as you may know, the Supreme Court came out with that PLDT decision. No? And shortly thereafter, the SEC came out with a memorandum circular, basically saying, hey guys, the Supreme Court has spoken. Okay? Those companies that are not compliant with the Supreme Court decision on the nationality requirement, you have 1 year to cure the defect.
1 year.
1 year. My question is, why did the SEC not do that, adopt the same approach in the case of Rappler? That's purely legal, no? But the SEC could have done it, no? In fact, I was going, because we're talking legal here, the SEC invoked a provision in the Securities Regulation Code to justify its decision revoking the certificate of registration of Rappler Holdings and Rappler Inc. And the provision they cited says that every contract, okay, that is in violation of the provisions of the Securities Regulation Code declared is void. Look at the way the law is provided. It says contract. So the most that the SEC could have done was to invalidate the question provision,
Okay.
to remove that, because the agreement can subsist even without that provision. And the best example is that the North Media base of PDR, it does not have that provision, yet it's a valid contract. A contractual clause in a contract is itself a contract. So the SEC should have, at the most, if I were the SEC, I would have invalidated that, assuming that they did not agree with the waiver given by Umidyar, which they claim to be what they call this technically deficient, or they could have, the SEC could have just invalidated that clause in the Umidyar if they were, because that, for me that should have been done. Assuming that that clause is inseparable from the other provisions of the NBN contract, the most that they could have done was to invalidate the Umidyar PDR. Now, I was wondering, I don't know who the counsel of Umidyar is. Okay? You know, Umidyar was directly prejudiced by this SEC decision. You know why? Because it revoked the PDR of Umidyar. But Umidyar was never heard.
So why Omidyar, do you think?
Because it's Umidyar's PDR that contains the question provision.
But never ask them for
But
their side.
the SEC never asked them for its side. Why did the SEC revoke an investment instrument of Umidyar without giving Umidyar due process?
Okay. You mentioned SEC had its own policies. There's a Supreme Court decision that basically guides how the process of similar cases should be. The head of SEC is actually quite credible, or has enjoyed popularity and credibility and professionalism. Did this decision surprise you personally?
I know the chairperson of the SEC because we come from the same law firm. Okay, and it surprised me. But anyway, I'm willing to give benefit of the doubt. We may differ in opinions. We are just professionals. Okay, I respect the decision, but I think they should also they respect our own position. In fact, ultimately, it's the courts of law that will decide this. We may differ in opinion, but I remain to be a supporter of the SEC because I really believe in a very strong SEC. I believe in a strong capital markets. I'm involved in the National Competitiveness Council. I would like to believe I've done my bit when I was at the exchange trying to make the business environment conducive to more investments. And in fairness to them, the SEC has done its bit in trying to lay down a framework, in trying to have an environment that is business friendly. But things like this, we shoot ourselves in the foot, so to speak. Yeah. To that extent, I'm sad. But we may differ in opinion, nothing personal. Walang personalan dito.
Okay. Clearly, I think what's been made very clear during this conversation is that this is beyond Rappler. This is a press freedom issue, and it has its consequences with businesses as well as foreign investors. How long do you think this whole case will take, and what are the, I guess, possible downfalls during that period of time?
You know, it's no secret that cases take quite a while to be resolved, up to the Supreme Court level. Because ultimately, it will be the Supreme Court who will say, Natasha, who is right or wrong, okay? And unfortunately, in our judicial system, this cannot take place overnight. But I'm glad that no less than the SEC chairperson and the official or spokesman of the SEC have publicly come out that until their decision becomes final and executory, they will not implement the order of revocation. And because of that, I'm very happy. I'm very happy for press freedom. I'm very happy for you guys. Because if the SEC immediately implements its revocation order, you're out of the job. I understand there are almost 100 of you. NBN will not be paid. And what an disastrous impact would that make on the rights of an innocent investor? So I'm glad that the SEC has come out publicly that they will not implement their decision to revoke until it becomes final and executory. And this decision will become final executory only after the Supreme Court has spoken. So you guys here, it should be business as usual.
If the license were revoked, would that still give Rappler the right to publish? How else would that affect us who work here?
I really don't know, okay? But I would trust that you guys will find a way, okay? For example, Rappler can relocate in another place, in another jurisdiction. I don't know, but and they can treat you as freelancers. There are other legal options, but it's different, no? It's different to belong to a Philippine company that is exclusively owned and managed by Filipinos. Okay, it's different, no? It's different to have a corporate vehicle that does business in the Philippines. Okay, it's different to have an employer that is purely Filipino. Okay, so while it's doable, I think there may be some practical difficulties. Yeah, would you want to be just a freelancer all throughout your life? I know you guys believe in Rappler because you're young here. I understand that your median age is 23. And I feel the idealism, the energy within the room. And I think as your lawyer, I'll see to it that that will continue to happen.
Thank you. Just to wrap up, could you, I guess, what would you want to tell critics who have said Rappler deserves this decision because we broke the law and this is not a question of press freedom, that no one is above the law? What are your final words, or what are your what would you like them to know about this case and about the situation?
You know, I've been a lawyer, a corporate and business a lawyer for years. And I want to assure the public that there was no violation of law whatsoever. Okay, so we can debate, but I think objectively at the end of the day, if you look at the issue objectively, I don't think there's any iota of violation. I may be biased because I'm the lawyer, but I've looked at it even before I was officially engaged as a lawyer.
Thank you, Attorney Lim.
Thank you, Natasha.
And that was Attorney Francis Lim, the counsel for Rappler and former president of the Philippine Stock Exchange. I'm Natasha Gutierrez. Thank you for joining us.